Governor Otter, you may begin.
Well, thank you, Mr. Chairman, and it's my pleasure to be here on behalf of the state of Idaho. I want to thank you, Chairman Hastings, and also Ranking Member Markey, for the opportunity to come before this committee and explain the concerns that Idahoans have surrounding Interior Secretary Salazar Secretarial Order number 3310. After Secretary Salazar's order was released, there have been numerous interest groups, members of Congress, and several governors, including myself and my colleague to my left, who have conveyed great frustration and deep concern over this designation. The Secretary's wildlands policy has placed a higher priority on protection of wilderness characteristics and regulated other than multiple use to a position of lesser importance. This drastic change in public policy for public lands was done without public input. With land use decisions shifted to Washington, D.C., the legitimate rights of states and the peoples of those states to have input on activities within their borders has been disregarded. Once lands are designated as wild lands by the BLM, multiple use becomes greatly restricted. These restrictions were signified and have the impact on the construction of new infrastructure. For example, critical transmission corridors and the operation and maintenance of existing facilities on these very lands. Every project will require a new NEPA analysis. These new steps offer opponents of ongoing projects and new adventures to delay them all. The order potentially makes the process for citing new energy-related projects even more difficult. Essentially, it represents an even greater chilling effect on developers who already view access to BLM-managed property as a daunting task. More importantly, the implementation of this order could impact energy projects that have already begun and spent millions of dollars on projects in the current permitting process. In Idaho, several significant energy-related projects, and might I add, totally green energy projects, such as China Mountain Wind, Gateway West Transmission, Boardman to Hemingway Transmission, are already fully engaged in the right-of-way signing process. There is no indication that these projects would be spared from the potential impacts of this order. The BLM has a history of being paralyzed by the mere threat of lawsuits and any pending decisions that are likely to be delayed for months, if not years. The order provides several new avenues for the anti-progress groups to challenge BLM's decisions, which eventually will lead to endless litigation. There is a concern about funding and manpower to complete projects currently in progress, while BLM's manpower is redirected to re-inventorying lands for wilderness characteristics. How does the BLM implement such a vast undertaking without undermining projects already underway? Congress has indicated that they will not fund the BLM to conduct these new wilderness inventories. There is a speculation amid us already that BLM will require anyone seeking a permit to pay for the wilderness inventory on the footprint of the project in the surrounding areas. The impact to energy projects and grazers and present multiple use could be horrendous. The BLM contends in its own talking points that this new policy will have no effect on lands that are not under BLM's jurisdictions. Simply look at the map over here to my far left, and the yellow area are the BLM lands. And that these lands of the western states, as you look at it, you will see that the state and private lands are intermingled with endowment lands of the states. Issues of access and management have not been addressed. The secretarial order has the potential to economically impact the state endowment lands, which are the benefits primarily for our school children. The Omnibus Public Lands Management Act of 2009 designated of new wilderness of 117,000 acres of Owyhee County in Idaho, in southwest Idaho, as wilderness. Area acres were released to be managed for multiple use. This collaborative effort, championed by Senator Mike Crapo for years and now approved by Congress, is now in jeopardy. The partners in this endeavor are concerned that whether or not the parcels released as a result of that agreement in the de facto wilderness designation of the wilderness study areas will now be re-inventoried as lands with wilderness characteristics and could be recognized as wildlands. Under the planning rules outlined by BLM directive, it only follows that lands previously deemed wilderness study areas would become wildlands. If this happens as BLM follows the Secretary's planning procedures, any future state and local collaborative efforts, such as the Owyhee Canyonlands, with the federal agencies will be jeopardized. The public will have no confidence in the federal government's process. Secretary Salazar has circumvented the authority not only of Congress in the process of designated wilderness areas, but the input of the public and the effect on western states and states' rights. This reflects the same type of top-down, one-size-fits-all management approach that Idaho was subjected to during the waning hours of the Clinton administration during the Forest Service roadless rule. In closing, Mr. Chairman, I urge Congress to take back its authority and prevent further development and implementation of Secretary Salazar's order. This order exempts stakeholders, threatens the spirit of collaboration and cooperation, weakens the process, discounts state sovereignty, and sends the message to the citizens of Idaho and every state in the West. The federal government will continue to treat the valuable and diverse open spaces of the West not as lands of many uses, but rather as lands of no use and no access for the people who live and work in Idaho and other western states. Mr. Chairman, members of the committee, thank you very much for your attention.